Good afternoon, everybody. Welcome back. My name is Chris Justice. I am an associate with Samfiru Tumarkin. And as always, I'm here today to hopefully answer as many employment law related questions as I can. So if you're tuning in today, definitely get your questions in. And as I say, I'll do my best to answer as many as I can in the time that I have. As always, if you've got questions regarding maybe something to do with a pre-working relationship issue, maybe you're at a company and you've got some questions about what's been going on while you've been there, or maybe you've been let go recently and you have some questions on your way out as far as what your rights are, what your entitlements are. As I say, get your questions in, and then I'll answer them to the best of my abilities. But before I do that, as always, I like to start off with a few topics. Some things that may be in the news as of late. And right now, it's just a continuing trend of layoffs happening across a variety of different sectors. In particular, this time around, and this is further to the acquisition of Shaw that Rogers had made. There have been a number of Rogers employees who have been let go. I've spoken to some already, those who've been let go as far as their severance packages are concerned. Whether or not the severance being offered by Rogers in these cases is fair and reasonable. And what I can say is that in general, if you're somebody who's been let go, whether it's in the context of Rogers or a different company, and you have been offered a package, you're definitely going to want to consult with a lawyer, get some legal advice before signing off on that package. Even if you think the package is fair, maybe your employer has told you that it's a fair offer. Maybe you've done some research and you're thinking that the offer is pretty good. It still makes good sense to give us a call, get some legal advice, and just make sure 100%, because the vast majority of packages, when they are offered, especially the first offer that's being given, is usually not the company's best offer. And unfortunately, also, too many people end up accepting these packages, not thinking that they're maybe entitled to more. And, in a lot of cases, we're talking about the difference between what they've been offered and tens of thousands of dollars extra. So, as I say, if you're someone in the situation dealing with Rogers, definitely give us a shout. If you're someone who's otherwise just lost their job due to cuts, across the economy, depending on what sector you're in, give us a shout before signing off on any package. And sort of somewhat related to that, I'm sure some have heard this, but the internet service provider TechSavvy, they've announced that they're putting up the business for sale. And so a lot of people will oftentimes have questions for me as far as what happens to them when there's a purchase and sale. When the company that they've been working for, say, many, many years gets bought out by another company, what happens at that point? Because sometimes when these purchases and sale happen, the employee who worked for the one selling the business may be let go, and the purchaser of the business may decide not to take on that employee moving forward. And if that's the case, then there is definitely going to be severance owed to that employee from the business that sold to the purchaser. So that's number one. And again, you never want to sort of assume what's being offered is fair. You want to make sure you get what's appropriate in your case. And when it comes to severance packages, the main factors that the courts will often look at are things like your age at the time of termination, how long you've been at the company, as well as the position that you held at the time you were let go. So in that scenario, that's what I would suggest and should happen when a purchase and sale occurs. But there are also sometimes employees who get proposed an offer to buy the purchaser. So the company, I guess whoever may be buying TechSavvy, for instance, may actually want to keep a number of TechSavvy's former employees, and the purchaser may just want them now to continue under their brand. And sometimes when this happens, employees in this situation are presented with a contract, some sort of an employment agreement that would apply to the purchaser specifically, not the seller of the business. And so this is another situation where you're going to want to get legal advice, because you may think that signing the contract, you'll just continue working, doing the same thing, just, getting paid from a different organization. And you may not realize that by signing some contract that you've been told to sign could actually affect many of your rights, including your rights in the event of a termination. And so you could be in a scenario where, say, you're working for Tech Savvy for 10 years, they get bought out, you then join whoever buys them out. And as I say, you sign some paperwork, you get let go shortly thereafter. And then because of that paperwork or that document or contract you signed, you end up getting a lot less severance than had you not signed it and maybe just been let go by the business that was selling. So, as I say, anytime you're presented with a contract, whether it's to do with a purchase and sale or just in general, again, before signing it, you're going to want to get some legal advice so that at least you know what the contract is saying, what the terms are saying, so that, if there is something that happens in the future, you'll sort of understand the impact of these terms. And if you don't agree to the terms, you might have the ability to negotiate as well. So as I say, if you're in a purchase and sale situation, maybe you've been let go, still going to want to make sure you get a proper severance package. Maybe you've been offered continued employment by the employer. You're going to want to get some legal advice, especially if they're asking you to sign something. If the purchaser doesn't ask you to sign something and you just continue on working for that new company, as a matter of fact, then there's a good chance whatever terms that you had with the seller will stay in effect. And if there's no contract there, then you may not have to worry about anything limiting your rights. But either way, I think everyone should get some legal advice if they're in that situation. I've got some other topics I wanted to touch on, but I'm just going to answer a few questions first. So I've got one question from Brad Jansen on YouTube, who's asking whether or not employers have, the right or the obligation to pay for statutory holidays. And Brad is saying that their employer has never paid out for any of these days. And yes, if you are an employee, generally speaking, of course, there are statutory holidays for which you would get payment for. Although that's not to say that there aren't companies that don't pay out that amount to you. And that would, in most cases, be a breach of the law. It would be illegal, and it may actually be constituting a constructive dismissal. So anytime your employer is going against what the law says they're to provide to you, whether it's payment for stat holidays, could be overtime, could just be your regular wages, that employer has breached a term of your agreement. And as I say, that could be treated in the eyes of the law as though it was a termination, entitling you not only to your unpaid stat holidays or overtime or wages or vacation, but also entitling you to the same thing you would get if you were let go, which is your full severance rights. So if you're in a situation where your employer has not paid amounts that are owed by law, I think the first thing you should do is contact the employer and ask why they haven't done it. And depending on what the response is, definitely insist on that amount being paid. And if they still don't pay, then at least you've got a paper trail to say that you've approached the employer, you've addressed your concerns, and even in the face of those concerns, they're basically just telling you to go away. And as I say, you'll have a strong case for there being a breach of your employment contract with that employer. And then that employer may be in a bunch of hot water as a result of them breaching the law. So that's kind of how I deal with it there. But thanks for the question, Brad. I've got another one in from MJL on YouTube, who's saying that the dealership they work for just partnered and they were laid off due to a shortage of work, but there's a new employee taking over their work. What can I do? And this is from Mike. So in general, when somebody is laid off or I guess terminated from their position at a company, the company itself that's letting that person go doesn't need to have the best reason at all. Companies can typically lay employees off for pretty much any reason they want. Of course, with the one exception being that there can't be any outright discrimination. So in Mike's case, for example, it may be that a new employee is taking over their work, but that could also be the case if the company wanted to make some budget cuts, right? And let's say let go a few people, and then those who remain, they may give the responsibilities and duties of those who are let go to the people that are still there. And sometimes companies will do this, of course, to save money. Not to say that it's necessarily right for them to put more work on the plate of others, but there could be, I guess, a business-related reason for why you were let go and why somebody else had taken over your duties. Or another example could be, they let somebody go who's costing them a lot of money, and then thereafter they hire somebody new who maybe costs them half as much. Again, it doesn't mean there's necessarily discrimination there, and it could be easily the case that the company's within its rights to let you go. But having said that, if they're going to let you go due to a shortage of work, or even lay you off temporarily due to a shortage of work, that is likely going to be considered a termination, and you're going to be owed your full severance. So I would say, Mike, if you're in that situation, whether it's a permanent termination or just even a temporary layoff, I suggest you give us a call, because in all likelihood, you're probably not going to be getting a fair and reasonable severance package, and you're going to have to do some negotiation. But at the very least, I would say that's owed to you. And if there is further evidence of bad faith on the part of the employer, that may be something that you can use for added leverage in terms of getting a better settlement as well. But thanks for your question. And as I say, I think you should reach out and maybe schedule a consultation. I've got another one a question from Belinda on YouTube. Belinda is saying that they were hired as a remote worker several years ago, and their employer sent out a note to all staff saying they wanted everyone to come back into the office. And Belinda wants to know if they have to accept this, since they were never in the office. And that's a good question. So if you're an employee and you've been let go, or sorry, I should say, if you're an employee and you signed a written contract that specifically says you are to work from home, or the position's a remote working position, and there's no mention in the contract about, coming back into the office, or about the employer maybe having the ability to call you into the office if needed, then it would be a pretty clear example of a situation where remote work was a key or a fundamental term of your employment. There are also other scenarios where maybe there isn't a written contract, and you just sort of maybe sign up based on a handshake, but you literally work all of your time remotely, and now out of the blue, without much notice, you're being told to come back in. I think you could also argue that working remotely from home is an implied term of your contract, even if it may not be in writing. So I think, Belinda, it could come down to whether or not there is anything in writing that would at all speak to that company's ability to call people back. But I think for those who are specifically hired on as remote workers, or for the entirety of their tenure with the company have worked remotely from home, there's a very good argument to be made that that was the expectation, and that should continue. And so by an employer asking you to come back in, you could as well consider that to be a breach of the terms of your employment. And that also could constitute a constructive dismissal. So you would have the ability to basically say to your employer, look, this is what I signed up to. This is what I agreed. There's nothing anywhere that I've signed or agreed to that says I'm to come back into the office. And if you guys are going to insist that I do come back, that's just not something that I'm agreeable to. I'm willing to work remotely from home, but if that's not what you're willing to allow me to do, then, at that point, you may be able to consider your employment to be terminated, and that employer is going to have to provide you with your full severance rights. But I would say, Belinda, to probably give us a call. Better first to get some advice, just to get a better understanding of all the communications that have been passed back and forth, as well, maybe to talk about the existence of any kind of contract and what effect that would have. But also to make sure that you're kind of communicating with your employer moving forward in the right way, so that you can preserve your right to at least have as many options as possible if your employer sort of digs in and draws a line saying, there's just no way they're going to accommodate you. And actually, the issue of accommodation brings up another thing too. A lot of people work remotely from home, or have been working remotely from home. Maybe they've signed something that says it, maybe they haven't. But in working from home, they're better able to look after children. So they may have caregiving duties with respect to the family. And so if you're an employee who's being asked to come back in, but you need some time to, for example, get daycare coverage, or get somebody cover the kids while you're going back into the office, pretty much in all cases, your employer is going to be required to accommodate that request. And they can't just insist that you come back immediately without at least giving you time. Otherwise, if they don't, now they're getting into a bit of an issue when it comes to human rights legislation. There's possible violations of, someone on the basis of family status, pregnancy status, that kind of thing. So that's just a slight aside. Again, it doesn't matter if you've got a written contract saying you can work from home or not. If you require accommodation under human rights based grounds, then your employer can't just force you to come back immediately as though maybe it wants to. But hopefully that answers your question for now, Belinda. Thank you very much. I've got another one in from Ultric on YouTube who's saying they're 67 years old, employed for 4 years. They've been on short-term disability the last 6 months due to a respiratory infection, and now they have to potentially go to long-term disability. But they're also asking whether they should just negotiate a layoff or severance. So I think, Ultric, it will be difficult for you to negotiate a severance package if the employer has no interest in providing you with severance and no interest in terminating your employment. If you get the sense or the impression that your employer may be open to terminating your employment or negotiating some kind of a package, that's possible. But I think I would only suggest that if you really do want to leave that employment relationship and get something on your way out versus sticking around and coming back after your disability leave. Because if you're somebody who's on a disability leave for 6 months, a year, even in cases 2 or 3 years, whether it's short-term or long-term, your employer is generally going to be obligated to keep your position available, or at least one very similar to your position available. And a lot of times employers don't want to wait forever for an employee to come back. They think that if somebody's not back in the office or at work after 6 months or a year, that they've therefore waited long enough and they can just let that employee go. But as I say, for the most part, it doesn't matter if it's several months or even in cases several years, they're still going to have a general obligation to accommodate that employee while they're off on the medical leave. So I think, Ultric, it depends on what your goal is here. If you want to stick around, remain employed, get better, and then come back, then, as I say, you're going to be given a good amount of leeway in terms of time and recovery and all that before you can come back. And if there's any resistance from your employer in terms of trying to accommodate your status, your disability status, your medical status, then again, that could be problematic for them, which might lead to more options for you, not just in terms of severance, but also in terms of potential human rights damages. But that's assuming that you want to stick around or come back after your medical leave. If you don't want to do that and you want to try to just get some money while you're off or on your way out while you can, as I say, it just kind of depends on how willing the company is to do that, because that may sort of determine how much leverage you would have in trying to negotiate a package. But they may be open to it, and they may just be walking on eggshells because you're 67, you're on a medical leave of absence, and normally in that scenario, no employer is just going to say, we're going to terminate your employment, because they're going to be worried about the optics. So if it's coming from you first, that may give them a sense of a possible, what I would call a mutual separation package. But again, it could affect your leverage in terms of getting your maximum amount of severance. But definitely give us a shout, Ultric. I'm happy to talk about this further with you in a consultation and see where we go from there. I've got another question in from Juanita on YouTube, who's asking whether or not at-will employment agreements are allowed in Canada. Their employer has said that they are at-will employees, but they're not sure if this is true. So from my understanding, at-will is something that is referred to in the USA, essentially meaning that an employee can be terminated at will. And I'm not an American lawyer, but I do know that there are many laws south of the border that are a lot more beneficial and advantageous for employers, that can potentially allow US employers to let their employees go essentially at will, as the phrase suggests, without much, if any, severance. But that is not a term that is accepted in Canada. Employers can terminate without giving an employee any notice whatsoever in Canada, but in that event, they still have to pay out the full severance. Or employers can also terminate someone's employment and give them notice ahead of time, or a combination of notice and pay. So essentially in Canada, with Quebec being the exception, employers will have to provide pay in lieu of notice, notice itself, or a combination of the two if they let you go, and they can't simply get away with just letting you go without any severance whatsoever, unless it's a very, very, very unique or limited circumstance. So no, I would say in general, that term is not something that's acceptable in Canada. Assuming my understanding based on what you've said is also the same. But thank you, Juanita, for the question. I've got another question from Rick on Facebook, who was let go from their position after 6 years. And Rick is owed a large amount of back pay, and they're in the process of trying to get that from their employer. And Rick's also asking whether or not they can seek severance from the employer. So if you're somebody who's been let go, been terminated from their position after 6 years, depending on how old you are, depending on the position you had as a 6-year employee, you could get, as much as 6, 8, 10 months of severance. So I definitely think that it would be, of course, recommended that you seek severance if that's not been paid, especially if you've gone without work after being let go. And of course, not to mention the amount of back pay. So it kind of goes back to an earlier question that was asked regarding statutory holiday that's owed. If an employer has not paid you for time work for services given, then that's a breach of your employment agreement. The most basic idea of an employment contract is I will give you my time, my energy, efforts, provide a service, and in exchange, you'll pay me. So if you've done one thing and they haven't lived up to their bargain and they owe you back pay, then as I say, that's a clear breach of your agreement. And that alone would constitute a termination. But also there could be clear violations of the legislation in Ontario, at least as far as pay is concerned. So your employer not only would have to pay severance, but essentially what they've done is illegal. They've breached other pieces of legislation, and they could therefore be on the hook for a whole lot more than just your severance. So yes, definitely give us a shout, or if anyone's in a similar situation to Rick, to give us a shout, because there are some huge issues there and the employer needs to be aware of that. I've got another question in from Wendy on YouTube, who's asking or saying that their company has decreased their hours and they're not responding to questions about why this was done. Is there anything they can do? So again, sort of similar to the not paying back pay. If somebody signs up or agrees to a contract with a company to work, let's say 40 hours a week, and all of a sudden their employer comes to them and says, we're going to decrease your hours from 40 now down to 30 without that employee's consent or any contract that would let them do that, that is considered a significant change to the terms of someone's employment. And so depending on how many hours your employment is being decreased by, it could very easily constitute a constructive dismissal, especially given that you're not being told why it's done. Seems to be a non-response. So I think if you, Wendy, or frankly anyone is in a position where the terms of their employment are being changed without their consent, whether it's pay, hours, location, the position itself, maybe some of your seniority or responsibilities have been stripped away from you, just know that you have options and you don't want to be silent on these things. You want to, present your concerns in writing so that it's on record. And at that point, your employer is either going to do something about it or not. But if not, then at least you can say that you've pushed back, you've presented your concerns very clearly. And so it's not without trying. And again, that would then lead you down that constructive dismissal path where you could be seeking potentially significant amounts of severance. Depending on who you are, if you're terminated or constructively dismissed, you could be looking at upwards of 2 years of compensation just on the severance piece alone. So it can be very vital and important, but definitely give us a shout if you're someone in that situation. I've got a follow-up question from Juanita, just regarding the concept of at-will termination. Juanita saying that it's a U.S. employer, but they work for a Canadian branch. And so actually it's primarily where you work that's important. So a lot of times you may work for a company that's based out of the US, and they think that for that reason alone, even though you may have spent your entire time in Ontario, let's say working, that the US law applies. And in most cases, that's just not true. There could be a contract potentially that speaks to which law governs, but for the most part, employers are mistaken if they think that they can sort of take advantage of all the laws in the US, even though their employees, as a matter of fact, work out of Canada. So Juanita, I don't think that's going to be good enough for the US employer to argue on. A huge important factor is kind of where that employee is based out of, along with, like I say, the contract. So hopefully that adds some additional help for you there. Excuse me. I've got another question in from JR on YouTube, who's asking what employment laws constitute, explain, or outline shady hiring practices in regards to maintaining and receiving employment. So, the Employment Standards Act, JR, doesn't really speak to hiring practices per se. I think that if somebody, for instance, was not hired or hired specifically based on a protected ground under human rights, and there was evidence, let's say, to suggest that somebody was sort of not considered for reasons relating to race or gender or whatnot, and as I say, there was evidence in support of that, of course, that would constitute a shady hiring practice and could violate human rights legislation. So that would be one example where I guess the reason for why someone does or doesn't get a job or loses their job or whatnot, if, as I say, it's related at all to any protected ground under human rights, there would be an issue there. I mean, there are, frankly, JR, a number of different laws in a number of different contexts that you could connect to, I guess, hiring practices. So I think we'd be here for a while going through all of them. But I would suggest if you want to get a better understanding of, I guess, the main laws or pieces of legislation that relate to hiring practices and that I suppose impose certain obligations on employers when it comes to fairness, definitely give us a shout. We can set up a consultation and kind of talk you through it. And then I guess from there, depending on that information, relating to your own individual circumstance, you may have a case, you may not, but that's what I'd suggest at the moment. But thank you for your question. I've got another question from Henry on YouTube, who's in Alberta, and they've won an appeal from an unemployment tribunal. They say they were assaulted at work. Unemployment will not pay them or communicate, and they're asking for help. So, Henry, I'd probably need to have a bit more detail in terms of what the appeal was about, and I guess the connection between unemployment and the assault at work. I'm not sure if you were assaulted at work and were unable to work and were asking for sick benefits through EI or Service Canada. But it seems as though if you've won an appeal, then there should be something coming your way, or at least some communication. So I would say give us a shout. I think maybe forwarding some of the communications, the emails, the confirmation that you won the appeal and everything that has to do with that is probably going to be helpful in terms of giving more information. Because, I'm not sure why you're not being contacted after you've won the appeal. That seems strange to me. So I'd say give us a shout. We can set up a consultation and kind of have it delved in a bit deeper and hopefully get some options or get an idea for you of what's been going on. One more question, I guess, before I call it a day. I've got a question in from MJL. It's again Mike actually following up from his previous message. So Mike's saying that his role was designed for him because of a disability in the workplace. And that I guess WSIB and the employer had some cooperation, and he's asking if they can take the position away from him. No, I think that if you are given a role that's specifically designed for you, you're saying it's because of a disability. I would say that to the extent that you no longer require accommodation for your disability, your employer may be able to assign your previous role. It seems as though this role is sort of a modified type role based on your limitations. So I think, it could be, something that they could revert back to. But in general, if you've got a role and you've signed up to a role and you've agreed to a role, then they have to accommodate you in that role. So they can take the position away from you if by taking the position away, you mean terminate your position. But what they can't do is take a modified role away from you when you still require those modifications, right? I think that if you are given a role that is modified based on your medical needs, as I said before, as long as you have those needs, your employer should be accommodating it. So I don't know why they would take the position away from you and give you a different role, but it's going to come down to what your doctors think you're capable of doing. So your employer shouldn't be taking the role away from you Otherwise, there could be a clear danger of them discriminating against you based on disability and being in a whole, situation right there on its own. So it seems like there's a bit going on though, Mike. WSIB, the dealership, disability, all that kind of stuff. I think it's good if you give us a shout. We can schedule a consultation and go from there. But that'll do it for my time today, everyone. I thank you all for your questions. I'll be back for sure, so look out for me. But we do this thing very frequently, and our next live stream is actually tomorrow, which is June the 27th at 1 p.m. You see down below there with Madalena. And so if you have any questions, definitely tune in then. Ask her all your questions. I'm sure she'll answer as many as she can, just like me. And as far as I'm concerned, I'll see you all soon enough. But do take care and enjoy the rest of your day. Bye for now.